Patricia Van Haren, family law attorney. What happens if my income has changed and I'm earning less money since the time the spousal support orders were made? Or what happens if my spouse gets a job and they're earning more money? Spousal support can be modified anytime after the judgment has been entered based on a change in circumstances and the income of either party. If someone loses their job or someone finds a new job earning less money than they did at the time of the judgment was entered, they can go into court and request that the spousal support that they are paying be reduced based on their lower income. You'll want to make sure that you gather all the necessary information, such as offer letters, reasons for leaving the old position, and updated pay stubs showing that you're earning less money. The courts are not inclined to grant orders if you unilaterally quit your job and choose to take a job earning significantly less. However, if you are laid off and making good faith efforts to obtain employment and find a lower earning job, then the court will certainly take this into consideration. In cases where the supported party receives a significant pay increase, their spouse may choose to file a request for order to modify or terminate the spousal support based on a decreased need for spousal support. If the supported party is laid off from their position and they find a job with less pay, they may be able to go back to court and have their support increased. It is important to note, however, prior to the filing of any request for order, that the supported party may also seek to terminate or modify support at that time, as it is always the court's desire that both spouses be self-supporting within a reasonable time. When filing a request for order to modify spousal support, it is important to note that these orders may be made retroactive to the date of filing and service on the other party. In order to ensure that you have all the evidence you need to support your request, you may wish to set a later date for the hearing, but preserve retroactivity as to the orders for support. At any time after a judgment is entered, the parties may exchange on an annual basis a request for an updated income and expense declaration with income tax returns. However, no formal discovery request may be served after the day of judgment unless there's a pending request for order on the calendar. We had a case where our client was a supporting party. He had been laid off from a very lucrative position due to changes in the marketplace. He was able to find another position. However, his compensation was much lower than the time the judgment was entered. His former spouse had also received a significant pay increase since the time the judgment was entered. At the time the judgment was entered, the children were young and his spouse was only working on a part-time basis. At the time he lost his job, his spouse had successfully re-entered the workforce. When we filed our request for order and reopened the discovery in this case, we learned that the wife's compensation was actually equal to our client's in his new position. After reviewing the documents, we set a meeting with opposing counsel. In this meeting, we were able to review all the documents together and run several support calculation scenarios. In all these scenarios, the support calculator showed that there should be no spousal support paid to either party. We were able to come to an agreement before the court's hearing and terminated spousal support and made more agreements to terminate any ongoing spousal support. This protected both of the parties as the wife was continuing to grow in her career and could have then been obligated to pay support to her husband. Our client was very happy as it was also his growth to grow in his position, and he was free to do so without being concerned that his wife would later take him back to court for more money. If you have any questions about this, shoot us over an email or give us a call.